Good afternoon, everyone. So, today we are here for the rapid revision on TP Act 1882. Before I can start, just let me know if I am clearly visible and properly audible to everyone. So, if I am audible and visible, please comment, students. Yes. So, let us start. Good afternoon. Good afternoon. So today we are here for the rapid revision on TP Act 1882. Now before I can start, I'll just give you a okay. I would want you all to just go through a little bit on the history, okay, of TP Act. Now, as you can see my Bear Act here, right? Just zoom it a little more, right? So if you see TP Act 1882, you will find that it has how many chapters does TP Act have? Anyone who knows it? Who can tell me which is the last chapter of TP Act? How many chapters are there in TP Act? How many chapters and how many sections can you find in the Act? Can anyone let me know how many chapters and how many sections are there in the Act? Yes, good afternoon. Can anyone please tell me? Yes, Ish. So there are 8 chapters and there are 137 sections. Very good. There are 8 chapters and there are 137 sections. Very good. If you see the chapters, you will find that the first chapter is preliminary chapter, which has 4 sections. First 4 sections are in the chapter 1, preliminary. Now, chapter 2 is containing a lot of sections. It is one of the biggest chapter, one of the biggest because we also have mortgage. So we have of transfer of property by act of parties, right? And starts from section 5, right? And it ends at section 53A. So from section 5 till 53A, right? From 5 till 53A, we have chapter 2. Then we have chapter 3, which is of sales of immovable property. It's a very small chapter. It's just from section 54 to 57, 4 sections. As you could see that even in the first chapter, there were 4 sections. In chapter 3 also, we have 4 sections. Now we have chapter 4, right? Chapter 4 of mortgages is again one of the biggest chapters in TP Act because it starts from section 58, right? Mortgage starts from section 58 and ends at section 104. It contains mortgage and charge both. Mortgage is from 58 till 99, but charges is from 100 to 104. So the whole chapter 4 is from 58 to 104. Now we have chapter 5, which is of leases of immovable property, starting from 105 and till 117 only. So from 105 till 117. We have chapter 6, which is of exchange, again, which has 4 sections from 118 to 121. We have chapter 7 of gifts, which start from section 122 till 129. Chapter 8, which is the last chapter of transfer of actionable claims, starting from section 130 till section 137. And then we have the schedule, right? So this is clearly okay. This is the scheme of this act. right? This is how the act is divided into 8 chapters and 137 sections. So always whenever you go through the act, or whenever you are starting any act, you should always go through the content first, right? Always go through the content, then go through the preamble. So as you can see here also we have the preamble, and what does the preamble say? After the content, when you come to the preamble, always try to find out what is the object of the act. For what reason was this act enacted? What was the law before this act was enacted? Right? Is this the first act? How many amendments have been done uh, to the act? And why was it enacted? What was the reason of the enactment? Okay, this is again very important to understand what was the reason and what is the history of the act, right? So if you see the preamble, it reads, as you can see here in the on the screen also, we have the preamble which says, whereas it is expedient to define and amend certain parts of law relating to TP by act of parties, it is hereby enacted as follows. So, what is the object as given in the act, students? What is the object as given in the act? The object of TP Act is given in the preamble only. Okay, the object of TP Act, as you can see, is given in the preamble only. Any act, when it is enacted, it has an object, and the preamble is the thing which is the reflection of the whole act. In the beginning of almost or every act, you will find there is a preamble. And what does the preamble do? The preamble is actually reflecting the object of the act. So after that, when we start reading the sections, you will see that the objects which are enumerated in the preamble, or which the drafters of this act wanted to achieve through this act, is reflected in each and every section of the act, right? Now, what does the preamble lay? The preamble says that whereas it is expedient to define and amend certain parts of law relating to TP by act of parties. So, this was enacted because it was necessary to define, to give a definite meaning, right? To give a definite meaning and make some changes in the rules which were regulating at that time relating to transfer of property which was taking place between parties. So before this act was enacted, if you all know, uh, the transfer of property was dealt by the personal laws, right? By personal laws, and that was creating a lot of things, lot of different rules and regulation, and so one uniform law was required for transfer, right? So before the advent of British, the Hindus, the Muslims, they were being governed by their personal laws when it was coming for transfer of property. So later on, the first commission was appointed by by the British Queen Elizabeth II to remove the uncertainties on the matters relating to TP Act, and it was sent in India. And after certain amendments, it was introduced in the Legislative Council in 1877. You can see that the act came in 1882, but as you can see there is the date 17 February 1882 when it was enacted, which you can see on the uppermost right hand side of the act, 17 February 1882. And this bill was redrafted by second law commission again, है ना? And some provisions were borrowed from English law also on real property, law of conveyancing, and Property Act 1881. And it was shaped in such a manner that Indian population can easily understand what the law is. And after that, some important concepts were highlighted in this act, which we will see, which we will come to right now. So if you see the act, it is saying what? It is saying transfer by act of parties. If you can see the first line, an act to amend the law relating to the transfer of property by act of parties. So it's very important to understand that this is an act to amend the law relating to transfer of act by act of parties. Now, the thing which comes here is by act of parties. By act of parties. So, transfer by act of parties, if you see, is a transfer which is taking place between two living persons. See, I'm writing it here. Inter vivos, right? Inter vivos. What do you mean by the term transfer inter vivos? Transfer inter vivos means transfer between living persons. So this act is not dealing with anything which is taking place after the death of one person. Like, what kind of transfers take place after death of a person? Can anyone tell me? What kind of a transfer takes place after death of a person? What kind? Yes, very good, Ish. Succession. Correct. Correct. So succession is a thing. Inheritance is a thing which is taking place after death of a person. So after the propositus dies, after the propositus is dead, then his property is distributed among the heirs or among the legatees, or among whoever the heir apparents or successive heirs are. So succession is something which takes place after death. What else does takes place after death? That is will. Will takes we give effect to will, or the will is affected after the death of the person who has made the will. That is the legator. We call him legator. So will and succession are not coming within this ambit of TP Act. If you see the content also of TP Act, in no, yes, testamentary will, very good. So even if when you see the content ना, तो आपको कंटेंट में कहीं पर भी विल सक्सेशन ये सारे चैप्टर्स नहीं दिखेंगे टीपी एक्ट का, जैसे मैंने अभी आपको जब कंटेंट दिखाया, right? So we saw that okay, there is chapter 1 with 4 chapters, then there is chapter 2 जिसमें आपको सारे transfers of property by act of parties दिखेंगे, right? Which is still 53A. Then we have sale, mortgage, lease. So sale, mortgage, lease we have, and then we have gift, right? We have gift, we have exchange, we have transfer of actionable claims. But आपको यहाँ पर कहीं भी you will not find succession, you will not find will, you will not find inheritance. Why? Because this is not covered by TP Act. This is covered by personal laws, not by TP Act. And this is these kind of transfers are taking place. Whatever transfers are taking place between living person, that is transfer inter vivos, right? Like sale. So when I'm selling, the seller and the buyer, the vendor and the buyer, they both sell in their lifetime only. It takes place between living persons, not between non-living persons, not between one person who is dead, one person is who is alive. It takes place between two living persons. Even mortgage takes place between two living person. Lease takes place between two living person. Exchange takes place between two living persons, right? So these are the things which are covered by TP Act. So any kind of transfer which is under will, or which is under inheritance, or by operation of law after death of one party is not covered by TP Act. So it is not transfer of property by act of parties. Transfer of property by act of parties is something which takes place automatically between living person. So any transfer of property by operation of law, that is governed by personal laws, okay, not by TP Act. Will, inheritance, right? So first thing first, object of TP Act, if I tell you, is the transfer of property act is giving me a definite, a clear and uniform law of transfer of immovable property by act of parties. It is modified, it is changed to suit the current socio-economic condition of India, right? And it is completing the law of contract also, because before this act also there was contract, but there was no enacted law for transfer. So TP Act completes contract act, and it fulfills completing the Indian Contract Act, right? And then it makes provision for inter-vivos transfer, that is between living person, right? Now, one thing which I want to ask you all: do you think TP Act is exhaustive? Do you think TP Act is exhaustive? What do you think is the scope of this act? Is it exhaustive or not exhaustive? Is TP Act exhaustive or not exhaustive? Yes, students. What do you think about TP Act? Is it exhaustive or is it not exhaustive? No answer coming. Not exhaustive, right? So TP Act, if you see, is not exhaustive. Why is it not exhaustive? Because it does not contain complete law for all kinds of transfer in India, right? It is not containing complete law for all kinds of transfer in India. Remember that. Uh, there are several kinds of properties, right? So the act is not operating on all kind of properties. Firstly, it does not deal with movable property. Movable property ke transfer se we have sale of goods act, right? For that, so it is not exhaustive in that case. Also, it is not covering any transfer which operates by operation of law or through will, that is also not covered. So it is not exhaustive relating to all kinds of transfer, and it deals mainly with transfer of immovable properties. पहला तो ये आप ये चीज है. It is not exhaustive. Transfer by operation of law is not included here. We have transfer mainly of immovable properties, right? So if you see from section 5 till section 37, right, of the chapter 2, if you see this chapter 5 till 37 of TP Act, chapter 5 I'm saying, sorry, section 5 to 37 of TP Act, that is applicable to both kinds of properties. When you see section 5 to 37, you will see movable as well as immovable. Remaining sections, that is from 38 to 53A, contains only immovable property. And then there are certain specific transfer which is not limited to immovable property like gift and all. We will see that. So gift and exchange also of movable is included. Then Muslim law is also, if when we'll come to the section, we will see, if you see section 2 of this act, you will see that it does not affect any inconsistent rule of Muslim personal law, right? That is also one thing. And section 2 also exempts certain incidents of contract or constitution of property from operation of this act. Plus, TP Act has territorial limitation also. So it is not applicable to certain territories like Punjab and all, right? In other parts of the country where the act is applicable, it was not enforced at one stretch. It was applicable to different territories on different occasions. So this is also one thing which you have to look forward to. Seeing the preamble says about the short title. Section 1 talks about the short title, commencement, and extent. So, if you see the short title, it is TP Act, Transfer of Property Act 1882. Yes, yes, very good. It only defines and amends immovable property between living persons. Yes, and certain sections of this act is also covering movable property. Okay. And if you see that right hand side, if you see the right hand side of the act, 17 February 1882 is the date of enactment, and the date on which it came into force was first day of July 1882. And the extent also, it extends in the first instance to whole of India, except some portions which are mentioned here, because this act did not come into force on one occasion. It was enacted, and it came into force on different occasions at different places. So you will see that also in section 1. Okay. Coming to section 2, it talks about repeal of act, saving of certain enactments, incidents, right, liabilities, etc. So before the commencement of TP Act in India, uh, you know, uh, transfers were also governed by principles of equity and certain statutes. So after this act, there was no need of the old law. So accordingly, Section 2 provides for repeal of old law and statute which deals with TP Act, which deals with transfer of property in India. And while repealing the earlier statute, if you see section 2, it is saving certain pre existing enactment. So while it is repealing, it is also saving certain pre existing enactment and also some rights and incidents of property, right? So when you see certain things, the provisions of act do not affect what does not it affect? See, it does not affect acts and statutes not expressly repealed, है ना? देखो, provision of enactment not expressly repealed, it is not going to effect. Terms or incidents of contract or constitution of property, rights liability arising out of legal relation, and save as provided by section 57 and chapter 4, it does not affect something which is also coming by operation of law. And nothing in this chapter will dim to affect any rule of Mohammedan law also. So this is savings chapter, and repeat. Also talks about repeals and saving. Interpretation clause. If you see now, if I talk about interpretation clause of this act, a very important, very important section of TP Act is interpretation clause, where you will find the meaning, okay, of many things. So the first thing is relating to immovable property. When we talk of TP Act, we mean that we are talking of immovable property. है ना? We're talking of immovable property. So immovable property according to TP Act is not including standing timber, growing crops or grass. So standing timber, growing crops and grasses are movable property, right? Apart from that, immovable property includes what? So it is talking about, if you see this definition, if you see the definition which is given in section 3, it's not clear and complete regarding immovable property act, immovable property, sorry. So this act is not defining immovable property completely and clearly, right? So what does it you know how do you define immovable property if this act is not defining it in the interpretation clause? Who can tell me? Certain important words and terms have been defined, have been interpreted in the clause, but if you see the definition of immovable property, I don't find it clear, I don't find it complete. So what is it, student? Can anyone tell me? What is an immovable property? Where do you get the definition? It was only telling that this act is only telling that immovable property does not include standing timber, then growing crops and uh, grass, right? Growing crops or grass. Then what does it include? So it is talking about does not include. Then what does it include? How do we know? What does it include? For that, we need to see the General Clauses Act, the definition given in the General Clauses Act of 1897. If you see section 4, very good Priyanka, if you see section 4 of General Clauses Act, that has defined immovable property. Now, here, as it talks about exclusion, what is not included, there it talks about what is included. Anyone can tell me what does a immovable property include? What does immovable property include, students? What does immovable property include? Who can tell me? Write in the comment box. You have the comment box open for your questions or for your views on it, for your answers also. Very good, Ish. So Ish has mentioned land and anything attached to earth. So if you see General Clauses Act, it defines immovable property as land. The first thing is land, benefit arising out of land. First is land. This is what the General Clauses Act Section 4 talks of. It includes land, benefits to arise out of land, and things attached to the earth. ठीक है, लैंड तो ये इंक्लूड करता है. इमूवेबल प्रॉपर्टी क्या है? लैंड इमूवेबल प्रॉपर्टी है. Benefits to arise out of land is also immovable property, and things attached to earth is also immovable property. So section 3 of TP Act has to be read with section 4 of General Clauses Act in order to get a complete meaning of immovable property. Because हम यहाँ बात करने वाले हैं immovable property की ही in the coming sections also. सो इमूवेबल प्रॉपर्टी का डेफिनेशन समझना बहुत जरूरी है, और आपको सेक्शन 3 पढ़ना है विथ सेक्शन 4 ऑफ जनरल क्लॉजेस एक्ट टू अंडरस्टैंड द प्रॉपर मीनिंग एंड द कंप्लीट मीनिंग ऑफ इमूवेबल प्रॉपर्टी. सो इमूवेबल प्रॉपर्टी इंक्लूड्स लैंड, बेनिफिट्स अराइजिंग आउट ऑफ लैंड, एंड थिंग्स अटैच्ड टू अर्थ. अब थिंग्स अटैच्ड टू अर्थ मतलब क्या होता है? थिंग्स, ये दोनों चीजें तो ठीक है, लैंड एंड बेनिफिट अराइजिंग आउट ऑफ लैंड. लैंड मीन्स द सर्फेस ऑफ द अर्थ एंड एवरीथिंग अपॉन द सर्फेस, ऑल्सो अंडरनीथ. Benefits arising out of land, like the benefit which you are getting, many benefits you get out of a land, like you can catch fishes on the land, you have a right to ferry, right to tenant to leave. All these things are the benefits you get out of the land. And things attached to earth. Now, what are the things which are attached to earth? What things are attached to earth? There are things which are embedded in the earth. There are things attached to what is embedded in the earth, and things rooted in the earth also. So, things attached to earth, things attached to what is embedded in the earth, and also things rooted in the earth, except standing timber, growing crops, or growing grass. Right? तो ये चीज आपको देखनी है. Please write in the comment section what are the things attached to earth. Please write it down, students. Things attached to earth, please write in the comment section. No answer is coming from anyone. What are things attached to earth? I told you just now. Things embedded in the earth, things attached to what is embedded in the earth, and things rooted in the earth. Very good, Priyanka. And what is the things rooted in the earth? Things rooted in the earth, but since TP Act का section 3 is already telling you कि it's not including standing timber, growing crops or grass, तो हम things rooted in the earth से इसको हटा देंगे. So things rooted in the earth is a movable property good, except standing timber, growing crops or grass. Right? So this is the complete definition of immovable property. So what is movable property? If immovable property is this, what we have said, then what is movable property, students? What is movable property? Movable property अगर आप देखो तो जो भी प्रॉपर्टी इमूवेबल नहीं है वो मूवेबल है. And movable property is not defined. Is movable property defined in TP Act? You will not find the definition in TP Act. ठीक है. So of course movable में हम standing timber, growing crops और grasses को ला सकते हैं because वो excluded है TP Act में. मतलब if it is not immovable property then it is movable property only. ठीक है. अगर आप रजिस्ट्रेशन एक्ट देखो, रजिस्ट्रेशन एक्ट देखो, सेक्शन 2 क्लॉज 9 अगर आप देखो रजिस्ट्रेशन एक्ट का, वहां भी मूवेबल प्रॉपर्टी डिफाइंड है. एंड इट इंक्लूड्स स्टैंडिंग टिम्बर, ग्रोइंग क्रॉप्स एंड ग्रास, फ्रूट्स ऑन ट्रीज, right? And property of every description except immovable property. So that is movable property. Coming to the definition of instrument as defined in TP Act, instrument means a non-testamentary instrument. So what is instrument? Instrument is actually a legal document. What is instrument? It's a legal document. So whenever we are transferring something, we always do that in the form of a written document. If you're transferring your rights, if you're transferring your title or whatever ownership, anything you're transferring to other person, you do it with the help of a written document, and that written document is your instrument and it's a legal document. So TP Act says that instrument should be a non-testamentary instrument. That means non-testamentary instrument, that means testamentary instruments are not included. Matlab will is not included here in the instrument part. Coming to the definition of attested, attested मतलब आपको पता है हम attested क्यों करते हैं किसी भी document को, because हम attested करते हैं किसी भी document को for the ensuring the authenticity or the truthfulness that it was executed properly by the people who should have executed it. So the object is twofold: to determine that the property is, it was transferred with free consent, there was no fraud, no undue influence, and it is also confirming that the executant only and executed the document and no one else, है ना. तो ये है हमारा object of attestation. So here we bring witnesses and they attest the document. So the witnesses are known as attesting witnesses, right? According to section 3, you have to attestation should be done by two or more person, and if it is done by one witness it is not valid. So the attesting witnesses should see that the executant is only signing the instrument. Yeah, he's fixing his thumb impression, right? And the attesting witness also has to sign the instrument in front of the executant. So it shouldn't be that executant ने sign कर लिया और हम बाद में आकर sign कर रहे हैं. नहीं, हमें देखना है कि executant ने ही sign करा है. We should be present at the time when the executant is signing the document. Then come to registration. What is register? Registration is a process where you are officially recording your document. So registration is a process through which you officially record your document, and it also takes place under the provision of Indian Registration Act 1908. So when you register a document, it becomes a very important and valuable evidence regarding the statements made in the document, right? So this is registration, which is a process through which you are officially recording your document. कम टू एक्शनेबल क्लेम. एक्शनेबल क्लेम हम चैप्टर 8 में भी देखेंगे, ठीक है. एक्शनेबल क्लेम हम चैप्टर 8 में भी देखेंगे. It's a full chapter for actionable claims under section in chapter 8. But actionable claim का definition section 3 में it's already defined, right? Now what is actionable claim according to, see attached to a definition. And what is actionable claim? Means a claim to any debt other than a debt secured by mortgage of immovable property or by hypothecation or pledge of movable property, or to any beneficial interest in movable property not in possession, either actual or constructive of the claimant, which the civil courts recognize as affording ground for relief, whether such debt or beneficial interest be existent, occurring, conditional or contingent, right? So actionable claim का definition अगर आप देखो in section 3 of this act, in section 3 of this act, if you see the definition of actionable claim, you will find that there are two kinds of property. One is tangible, one is intangible. Okay, tangible is something which has physical existence, you can see. Intangible is something you cannot see. Now these are debt. Actionable claims are actually unsecured money debt. ठीक है, अनसिक्योर्ड मनी डेट या फिर कोई क्लेम, या तो ये अनसिक्योर्ड मनी डेट होता है। अनसिक्योर्ड मनी डेट मीन्स जिसके लिए कोई सिक्योरिटी नहीं है, डेटर के पास, क्रेडिटर के पास कोई सिक्योरिटी नहीं रखी गई है, राइट? सो दैट इज अनसिक्योर्ड मनी डेट, and this debt can be existing, can be accruing, can be conditional. And what is the claim? And second, it will be a claim to beneficial interest in movable property which is not in possession of the claimant, right? So if you have a right to take the possession of a movable property, if you are having the right to take possession of of a movable property from the position of other, that is the actionable claim of yours. So for example, if I am selling you 50 bags of wheat, if I am selling you 50 bags of wheat, but you have not taken it yet, the bags of wheat are still in my godown, you tell me that I'll take it after an hour, so you will have a right to take possession of the bags of wheat from the my godown, and that is your actionable claim, that is your claim to the beneficial interest. Okay, so this is actionable claim which cannot be seen. So like you have a claim for to the, you have a claim for rent to your tenant, you have a claim for money due under insurance policy, all these are actionable claim. Come to notice. नोटिस मतलब क्या होता है? नोटिस मतलब कि आपको किसी एक फैक्ट के बारे में नॉलेज या इंफॉर्मेशन है, राइट? नोटिस मीन्स दैट यू हैव नॉलेज और इंफॉर्मेशन ऑफ अ फैक्ट, and if the person has knowledge of any fact and it can be proved कि he had the knowledge, then he is said to have notice of the fact also. नोटिस मतलब ही होता है कि आपको नॉलेज या इंफॉर्मेशन है। अब नोटिस जो होता है वो एक्चुअल भी हो सकता है या कंस्ट्रक्टिव भी हो सकता है। एक्चुअल या फिर जो एक्सप्रेस नोटिस होता है वो डायरेक्ट नोटिस होता है। डायरेक्ट नॉलेज या इन्फॉर्मेशन हम दे देते हैं किसी को कि देखो ऐसे ऐसे आप आपके पास एक नोटिस आ रहा है। और कंस्ट्रक्टिव नोटिस जो होता है वो इक्विटी पे बेस्ड है। पूरा का पूरा टीपी एक्ट अगर आप देखो उसमें से काफी सारे पोर्शन है जो इक्विटी पे बेस्ड है। सो इफ अ पर्सन इज एक्चुअली ही डजंट नो अबाउट अ फैक्ट बट द कोर्ट इज ट्रीटिंग दैट इसको नॉलेज होनी चाहिए, then it is, if it can be presumed that you have knowledge, then it is constructive notice. हमने आपको expressly नहीं बताया about the notice, but a court is presuming that you should have the notice in this circumstance, so then it is deemed to be, you are deemed to be having constructive notice of a fact, राइट? एंड कंस्ट्रक्टिव नोटिस का जो प्रिजम्पशन है वो फॉलोइंग आप सर्कमस्टांसेस से बना सकते हो, जैसे कि विलफुल एब्सटेंशन फ्रॉम एन इंक्वायरी और सच। मैंने आपको बुलाया, आपने नोटिस रिसीव नहीं किया बट आप विलफुली एब्सटेन कर रहे हो फ्रॉम एनी सर्च और फ्रॉम एन इंक्वायरी, देन द कोर्ट विल presume that you have a constructive notice about it। या ग्रॉस नेग्लिजेंस है ना, नेग्लिजेंस मतलब क्या होता है? केयरलेसनेस। So if you are grossly negligent and you are willfully abstaining from inquiry also, they are almost similar. So you will be presumed, it will be presumed that you have constructive notice of the fact. Now if you see the explanation part, we have also have one explanation 1 to section 3 that provides that registration of a document is notice of all facts stating in a document। तो अगर मैंने किसी एक डॉक्यूमेंट को रजिस्टर कराया है, that means that I have notice of the facts। Okay, I have notice of the fact। तो ये हो गया अबाउट द एक्सप्लेनेशन, ठीक है। अब आप आ जाओ सेक्शन 4 पर। सेक्शन 4 अगर आप देखो, है ना, सेक्शन 4 जो है वो बात करता है that the chapters and section of this act which relates to contract shall be taken as part of Indian Contract Act, and section 54 का paragraph 2, 3, 59, 107, 123 shall be read as supplement to Indian Registration Act। So if you, as if you see this act, uh, I have already told you that TP Act is completing what Indian Contract Act. Because अगर हम किसी भी कॉन्ट्रैक्ट को, है ना, जो हम एग्जीक्यूट कर रहे हैं इन द फॉर्म ऑफ टीपी, फॉर विच आई वांट टू मेक अ कॉन्ट्रैक्ट, द वेरी पर्पस ऑफ कॉन्ट्रैक्ट विल रिमेन अनफुलफिल्ड अगर हम उसे टीपी एक्ट के अकॉर्डिंग एग्जीक्यूट नहीं कर रहे हैं, राइट? सो टीपी एक्ट इज कंप्लीटिंग कॉन्ट्रैक्ट एक्ट, and and there are some sections, if you see, which is 54 clause 2 and 3, 59, 107 and 123. ये अगर आप देखो तो ये आपको इंडियन रजिस्ट्रेशन एक्ट के साथ पढ़ना है, बिकॉज these sections are providing for registration of document under sale, under 107, that is under mortgage, ठीक है, lease and gift of immovable property. So registration is compulsory. So here the registration of document and the procedure has to be according to the registration act. So that is why TP Act is necessarily supplemental. These provisions of TP Act are necessarily supplemental to the Indian Registration Act. Come to section 5 now. This is now chapter 2 of transfer of property by act of parties. Now this is a very important chapter. I don't need to tell anything about this chapter because it's very 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 important. Section 5 से start होता है till section 53A. This chapter will extend, and all sections are important. I will mark the important sections when we are doing. तो वहाँ पर हमें हमें section 3 पढ़ना ही है, ठीक है? सेक्शन 3 बहुत इंपॉर्टेंट है, फ्रॉम सेक्शन 1 टू सेक्शन 4. इफ यू सी, if you want to read a section in detail, that should be section 1 and 3, right? From section 1 and 3 is important. Now come to section 5, which is again a very important section. You cannot miss 5 से 53A जो है, अगर आप देखो तो सेक्शन 5 आप मिस नहीं कर सकते हो. क्यों नहीं कर सकते हो? बिकॉज सेक्शन 5 में डिफाइंड है ट्रांसफर ऑफ प्रॉपर्टी, whether movable or immovable, right? 5 to 53A deals with ट्रांसफर ऑफ प्रॉपर्टी का डेफिनेशन. सो अगर हम डेफिनेशन देखें टीपी का, इट मीन्स एन एक्ट बाय विच अ लिविंग पर्सन conveys property in present or in future to one or more living person, to one or more other living person, or to himself and one or more other living person. So a person can also transfer to himself. So can I transfer one property? Can I sell my property to me only? Can that be done? What do you think? If you see the definition, it says that you can transfer your property to yourself also, to himself also. So can I sell my property to me? Can you sell your property to yourself? What do you think? Can you sell your property to yourself is my question. Can you sell your property to yourself is my question. You can answer this. No answer is coming from anyone. And in this section, living person includes a company or association or body of individuals, whether incorporated or not. But nothing herein contained shall affect any law for the time being in force relating to transfer of property to or by companies, association or bodies of individual. तो अगर आप टीपी एक्ट का डेफिनेशन देख, अगर आप ट्रांसफर ऑफ प्रॉपर्टी का डेफिनेशन देखो, तो पहली तो ये होनी चाहिए बाय एक्ट ऑफ पार्टीज. बाय एक्ट ऑफ पार्टीज मींस इट शुड बी अ ट्रांसफर बिटवीन टू लिविंग पर्सन. This is the most important thing that you have to keep in mind when you are studying about TP Act, that it is a conveyance between two living person. Okay, that means it is an act inter vivos. As I told you, it's an inter vivos transfer between two living person. ये दिमाग में बिल्कुल रखना है. And it is an act. Okay, so it is an activity. It's a process between two living person. ठीक है, लिविंग पर्सन जिससे आप क्या कर रहे हो, कन्वे कर रहे हो, कन्वे कर रहे हो मतलब आप अपनी प्रॉपर्टी को ट्रांसफर कर रहे हो. सो हिज कन्वेइंग is like his transferring. So conveyance means that the person is transferring all his rights and all his title to the person, to another person. And this conveyance can be done in present or in future. And it has to be done of a property. Now property means what? It is essentially a bundle of rights. If we talk about property, it's essentially a bundle of rights or interest. सो हम प्रॉपर्टी को ट्रांसफर कर रहे हैं यहाँ पर टू टू अनदर लिविंग पर्सन. हम कर सकते हैं या हम अपने आप को भी कर सकते हैं. ईश ने कहा है इन केस ऑफ ट्रस्टी ही ट्रांसफर्स टू हिमसेल्फ. यस ईश, दैट्स करेक्ट. सो यू ट्रांसफर योर प्रॉपर्टी टू योर सेल्फ. बट देर आर सर्टेन ट्रांजेक्शन जो हम ट्रांसफर नहीं मानते हैं, जैसे फैमिली सेटलमेंट. दैट इज नॉट अ ट्रांसफर ऑफ प्रॉपर्टी. किसी भी टाइप का फैमिली सेटलमेंट, किसी भी तरीके का कॉम्प्रोमाइज इज ऑल्सो नॉट अ ट्रांसफर ऑफ प्रॉपर्टी. पार्टीशन इज नॉट ट्रांसफर ऑफ प्रॉपर्टी. सरेंडरिंग इज ऑल्सो नॉट ट्रांसफर ऑफ प्रॉपर्टी. रिलीज हम बोल सकते हैं इज अ ट्रांसफर. रिलीज इज अ ट्रांसफर. रेलिंक्विशमेंट is not a transfer. Charge is also not a transfer of property, जो हम पढ़ेंगे यहाँ पे mortgage and charge, but charge is not a transfer. ठीक है. This is what section 5 talks about. And living persons यहाँ पे includes company or association or body of individual, whether incorporated or not. This is what is the definition of transfer of property under section 5. सेक्शन 6 पे आ जाते हैं. सेक्शन 6 अगेन बहुत इंपॉर्टेंट सेक्शन है. व्हाट मे बी ट्रांसफर. आप क्या क्या ट्रांसफर कर सकते हो. अब यहाँ लिखा है कि आप सारी चीजें ट्रांसफर कर सकते हो एक्सेप्ट दीज थिंग्स. राइट, लिखा है दैट आप सारी चीजें ट्रांसफर कर सकते हो एक्सेप्ट दीज थिंग्स. एंड देयर आर सम फ्रॉम ए टू आई 10 चीजों के बारे में यहाँ दिया है जिसे आप ट्रांसफर नहीं कर सकते हो. तो इन 10 चीजों को छोड़कर बाकी सारी चीजें ट्रांसफरेबल है. तो क्या क्या चीजें ट्रांसफर नहीं हो सकती हैं. अगर आप सेक्शन 6 पढ़ो तो वहां पे आप देखोगे द चांस ऑफ एन एयर एपरेंट. एयर एपरेंट मीन्स द चांस ऑफ एन एपरेंट एयर और अ पर्सन हु इज लाइक स्पेस सक्सेसनिस्ट. तो क्लॉज ए बात करता है स्पेस सक्सेसनिस्ट की या एयर एपरेंट की. स्पेस सक्सेसनिस्ट मीन्स एक्सपेक्टेशन ऑफ सक्सेशन. So if you are expecting that you will succeed, you have a chance of succession, you cannot transfer that. So chance of an heir apparent, chance of any relation who is, he has a chance of obtaining a legacy after the death of a kinsman, or any mere possibility of like nature जहाँ पे आप heir apparent या फिर खुद को space successionist मान रहे हो, जहाँ पे आप सोच रहे हो कि मेरे को मिल सकता है बट अभी आप बने नहीं हो ओनर, then you cannot transfer those things. Okay, you cannot transfer that property because you are not yet the owner. You are just expecting succession. You are an apparent heir but you are still not the real owner, not the real heir of the property. So जब तक आप real heir नहीं बन जाते हो, जब तक आप properly आप property आपके नाम पे नहीं हो जाती हो, आप transfer नहीं कर सकते हो. Clause B says about mere right of re-entry. So mere right of re-entry also cannot be transferred, right? Mere right of, so I have a right to re-enter and I will transfer it to you कि ठीक है आप जाके enter कर लो. Re-entry की right मेरी है और मैंने आपको transfer कर दिया कि ठीक है आप भी कर सकते हो. तो mere right of re-entry cannot be transferred. Clause C देखो, easement apart from dominant heritage, right? So any easement, what is easement? It's a right जो आप enjoy करते हो on any land and which is not created by any contract, but that is only, only when dominant heritage से जब आप dominant heritage को ट्रांसफर करोगे उसके साथ ही ईजमेंट्री राइट ट्रांसफर होती है. आप सिर्फ ईजमेंट राइट्स को ट्रांसफर नहीं कर सकते हो. So if I have a right to a way just because my house is falling in the same lane and I can use a way which belongs to some other person, but क्योंकि मेरे मेरे घर के जाने का रास्ता यही है तो that person is also allowing me to use it and I want to just transfer this right of way to someone else. That cannot be done. Either you have to transfer your dominant heritage and then only the right to way will also get transferred, otherwise you cannot transfer easementary right. Restricted interest as given in clause D cannot be transferred. Restricted interest means something which is restricted in its enjoyment to the owner personally, for example, is not transferable. Just because you are my friend, for example, I have given you one interest कि चलो ठीक है आप मेरा terrace use कर सकते हो because you are my friend. Except you, I am not allowing any other tenant to use my terrace, but since you are my friend, we have good relation, I'm telling you कि आप use कर सकते हो terrace. Now you want to sell that flat, and along with that flat you are also telling the person, the buyer, कि आप भी terrace use कर सकते हो, मैं भी use करता था. तो ये restricted interest था. ये सिर्फ ये यूज करने का, इंजॉय करने का प्रिविलेज मैंने सिर्फ आपको दिया था, बिकॉज यू आर माई फ्रेंड. यू कैन नॉट ट्रांसफर दिस रिस्ट्रिक्टेड इंटरेस्ट टू समवन एल्स. क्लॉज डीडी देखो, राइट टू फ्यूचर मेंटेनेंस ऑल्सो कैन नॉट बी ट्रांसफर्ड. राइट टू फ्यूचर मेंटेनेंस कैन नॉट बी ट्रांसफर्ड. राइट. So then clause E, mere right to sue. You cannot transfer your right to sue. So if someone is publishing a defamatory statement against me, right, I have a right to claim damages. Now if I transfer this right of sue to someone else, then that is not transferable. This is only my right to sue, and so only I should exercise it. Okay. Then come to clause F. Public salary, public office and salary of public officer cannot be transferred. तो अगर आप जुडिशरी में, अगर आप से फॉर एग्जांपल आप जज बन जाते हो, ठीक है, आपने एग्जाम दिया और आप जज बन गए. नाउ यू डोंट वांट द सीट, सो यू वांट टू ट्रांसफर इट टू योर ब्रदर, कि ठीक है, मुझे ये सीट नहीं चाहिए, मुझे ये ऑफिस नहीं चाहिए, मुझे ये ऑफिस आप किसी मेरे भाई को दे दो. तो विल इट, इज इट पॉसिबल टू ट्रांसफर योर ऑफिस टू समवन एल्स? इफ यू डोंट वांट टू टेक द अपॉइंटमेंट लेटर, सोचो आपने दो जगह का एग्जाम क्लियर कर लिया, आपने दिल्ली का भी एग्जाम क्लियर कर लिया और आपने एमपी का भी एग्जाम क्लियर कर लिया. तो दिल्ली वाला सीट यू आर लाइक ओके आई विल टेक इट, और क्योंकि एमपी में भी मैंने क्लियर कर लिया तो एमपी का सीट आई विल नॉट टेक, बट आई विल ट्रांसफर इट टू माई ब्रदर. कैन दैट बी डन? इज इट पॉसिबल? According to clause F of section 6, it is not possible, right? Even public salaries cannot be transferred. Then pension and stipends cannot be transferred. Okay, under clause G. Clause H talks about transfer opposed to nature of interest. Any transfer which is opposed to the nature of interest which is created, like for example also where the transfer is for any unlawful object or consideration, or if it is made to a person who is legally disqualified to be a transferee, then such cases of transfers are opposed to nature of interest and are cannot be transferred. Okay. And clause I, which is the 10th clause, it talks about untransferable right of occupancy. Untransferable right of occupancy also cannot be transferred. Any issue till now, students? You can post in the comment box. Come to section 7, which is talking about persons who are competent to transfer. So who are competent to transfer? If you see any person who is competent to contract is also competent to transfer. That means you should be a major. He should be of sound mind. He should be a major and of sound mind. So in case he's a major and if he's sound mind and with free consent, if he wants to transfer, then he is authorized to dispose of the property. But yes, one thing, that he should be the owner of the property also. Any person who wants to transfer is a major and is of sound mind, and also owner of the property can transfer his property. So these are the persons who are competent to transfer. Okay. So he should be competent to transfer and also entitled to transfer. That means you should be authorized to transfer the property. Apart from competency, that is you are major, sound mind, not otherwise disqualified, you should also be entitled. Entitled मतलब आपके पास authority होनी चाहिए for transfer. It should be your own property which you are transferring. Right. कम टू सेक्शन 8, ऑपरेशन ऑफ ट्रांसफर हम स्किप कर सकते हैं, बट यहाँ पर नॉट दैट इम्पोर्टेंट. सेक्शन 5 and 6 वाज वेरी इंपॉर्टेंट, बट अगर आप देखो इसको भी तो इट टॉक्स अबाउट डिफरेंट इंसिडेंट्स, है ना, कि आपको क्या क्या ट्रांसफर करना है. सो व्हेन यू आर ट्रांसफरिंग एनीथिंग, if the property is a land, the easement will also get transferred. Whatever rents and profits are there, that will also get transferred. So like this, they're talking about the operation. How do you transfer something? Okay, it should be first, so it should be an unqualified and unconditional transfer. So that is not that important. Just go through it. Come to oral transfer, section 9. It says that you can transfer without writing also in every case in which a writing is not expressly required by law. तो अगर राइटिंग में नहीं करना है, लॉ ने नहीं कुछ बोला है अबाउट राइटिंग, तो आप ओरली कर सकते हो। बट जहां जहां राइटिंग इज रिक्वायर्ड, है ना, जहाँ पे राइटिंग नेसेसरी नहीं है, वहां पे आप orally भी ट्रांसफर कर सकते हो with delivery of position. So delivery of position is one of the mode to transfer. And my second mode is registration. जहाँ registration necessary है वहां पे transfer has to be in writing, right? So at what places is registration compulsory? If you see gifting, in case of gift you have to register it. In case of sale, you have to, sale of any immovable property exceeding 100 rupees, you have to register it. सेल ऑफ रिवर्जन और अदर intangible property also आपको करना है. लीज फ्रॉम ईयर टू ईयर और फॉर अ टर्म एक्सीडिंग 1 ईयर को आपको रजिस्टर करना है. सिंपल मॉर्गेज को तो आपको रजिस्टर करना ही है irrespective of the amount secured. Any other kind of mortgage which is except mortgage by deposit of title deed, okay, that also you have to register. Exchange of immovable property exceeding 100 rupees also you need to register. Transfer of actionable claim. Transfer of actionable claim means registration is not necessary. Remember, transfer of actionable claim में registration is not necessary but writing is sufficient, so you have to at least do that in writing. ठीक है. सेक्शन 10 पे आ जाते हैं. सेक्शन 10 इज टॉकिंग अबाउट माई कंडीशन रिस्ट्रेनिंग एलियनेशन, है ना. कंडीशन रिस्ट्रेनिंग एलियनेशन, यहाँ पे हम बात कर रहे हैं अबाउट दोज कंडीशंस, कंडीशनल ट्रांसफर की बात कर रहे हैं. So if you are the owner of a property, you are competent to transfer. You also have the freedom of transferring this property unconditionally, or you can also put conditions to that. So either you transfer the property अनकंडीशनली और यू कैन पुट सर्टेन कंडीशन. तो जहां भी हम कंडीशन ले डाउन करते हैं उसे हम कंडीशनल ट्रांसफर बोलते हैं. एंड कंडीशंस जो होता है, अगर दो तरीके के कंडीशंस में आप आते हो, एक होता है एब्सोल्यूट रिस्ट्रेंट और एक होता है पार्शियल रिस्ट्रेंट. तो कोई भी ऐसा कंडीशन जो एब्सोल्यूटली रिस्ट्रेंट करता है एलियनेशन को, कोई भी ऐसा कंडीशन जो एब्सोल्युटली रिस्ट्रेन करता है एलियनेशन, under section 10 it is void. So restraint on alienation is absolute if it is totally taking away my rights of disposal. So absolutely restraining a property will make it void, will make the condition void. But if it is partial, now section 10 doesn't have any, it is not having any say about partial restraint, so it is silent about it. तो हम सोच सकते हैं that अच्छा ठीक है, जहाँ partial restraint है वो valid है और वो enforceable हो सकता है. But absolute restraint is void. Any condition absolutely restraining alienation is void. ठीक है. यहाँ exceptions है to the general rule that absolutely restraining alienation is void के हमारे पास दो exception है. First is in lease and second is married women who is not a Hindu, Muslim or Buddhist. They can validly impose a condition restraining alienation because that was made for the protection of the women's property. ठीक है. तो लीज के केस में, मैरिड वुमेन के केस में और आइडल के केस में, आइडल के भी केस में इट इज what any and it is an exception. वहां पे आप absolute restraint कर सकते हो on alienation. Apart from that you cannot restrain. Come to section 11, restriction repugnant to interest created. इतना important नहीं है तो हम इसको skip कर सकते हैं. ठीक है. Section 12 भी I'm skipping it, right? Come to section 13, which is very very important again. Section 13 is very very important. So I'm talking about all those sections which are important with respect to your exam. So I told you about section 3, I told you about section 5. Now section 1 पढ़ना है, section 3 पढ़ना है, section 5 and 6 पढ़ना है. 5 and 6 आप 7 और 8 भी पढ़ सकते हो, 9 में भी ओरल ट्रांसफर है, पढ़ लेना. 10 पढ़ना है. उसके बाद आप डायरेक्टली आ जाओ 13 पे. 13 क्या बोलता है? ट्रांसफर फॉर बेनिफिट ऑफ अनबॉर्न पर्सन, right? Now section 13 needs to be read with section 14, which is rule against perpetuity, है ना, rule against perpetuity. So section 13 और 14 हम साथ में ही पढ़ते हैं, right? So 13 talks about transfer for benefit of unborn person. So if I am transferring for the benefit of an unborn person, पहले तो मेरे को जानना है who is an unborn person, right? First, you need to understand who is an unborn person. So, an unborn person is a person who is not in existence, who is not yet born, but not only born but also not in existence in the womb of the mother. अभी वो आया ही नहीं है. Even in mother's womb he is not come. If someone is inside the mother's womb, like a lady is 3 months pregnant, 4 months pregnant, then that child is not an unborn person. He is a child in ventrasa mare, and he is a competent transferee. But someone who is not yet born, also not yet in mother's womb, also he's an unborn person, and we can transfer property for his benefit. But there are certain rules which you need to follow before transferring for benefit of unborn person. So ठीक है, आपने unborn person को transfer करा, but आप उसको directly transfer नहीं कर सकते हो. So I cannot transfer anything directly to an unborn person. I cannot transfer anything directly to the child of someone who is not yet in existence, right? But you can transfer it for his benefit. And for transferring for his benefit, you have to follow two conditions. पहले आपको एक प्रायर लाइफ इंटरेस्ट क्रिएट करना इन फेवर ऑफ द पर्सन, in favor of the unborn person. You have to create prior life interest, and secondly only absolute interest can be transferred in favor of unborn. तो पहले तो आप प्रायर लाइफ इंटरेस्ट क्रिएट कर लो, और जैसे ही बच्चा बॉर्न होता है आपको उसको सारा एब्सोल्यूट इंटरेस्ट देना, मतलब फुल इंटरेस्ट देना है. यू कैन नॉट कीप एनी रिमेनिंग इंटरेस्ट विथ योर सेल्फ, और यू कैन नॉट ट्रांसफर हिम पार्शियल इंटरेस्ट. If the child is born, you need to transfer him all the remaining interest, right? Now coming to section 14, it is talking about rule against perpetuity. Now here it says that, here it is actually talking about rule against remoteness of vesting, है ना. इसको rule against remoteness of vesting भी बोलते हैं. तो मैंने prior life interest create करा, very good, है ना, before transferring it to an unborn person, my absolute interest. But this perpetuity says that there should be a maximum remoteness of vesting. आप आप सारी जिंदगी परपिट्यूटी के लिए कंटिन्यूसली किसी को लाइफ इंटरेस्ट नहीं दे सकते हो. एंड जो अल्टीमेट बेनिफिशियरी है, जो मदर के वुम में है ना, he has to get the property at one stage. So what is the maximum remoteness of vesting? It should be the life of preceding interest plus the period of gestation, जब तक बच्चा मम्मी के अपने वुम में है, प्लस माइनॉरिटी ऑफ द अल्टीमेट बेनिफिशियरी. दैट मीन्स जैसे ही बच्चा मेजर होता है, आप उसको उसका इंटरेस्ट, आप उसको उसके प्रॉपर्टी को यू गिव इट टू हिम. सो द मैक्सिमम परमिसिबल रिमोटनेस ऑफ वेस्टिंग इज द लाइफ ऑफ द प्रिसीडिंग इंटरेस्ट plus the gestation period of the ultimate beneficiary plus minority. So section 13 and 14 is really important in that regard. ठीक है. Now there are some exceptions to the rule of perpetuity. That is, if you are transferring for the benefit of public, then you can transfer for continuous period, or in case of personal agreement also it is allowed. So in case of personal agreement and in case of public interest, it is allowed. Section 15 and 16 हम skip कर रहे हैं. Okay, 15, 16, 17 we are skipping. 18 also I'm skipping. I'm coming directly to section 19, which is important. तो 13 14 के बाद आप देखो वेस्टेड इंटरेस्ट एंड कंटिंजेंट इंटरेस्ट काफी इंपॉर्टेंट है. वेस्टेड इंटरेस्ट एंड कंटिंजेंट इंटरेस्ट इन सेक्शन 19 एंड सेक्शन 21. वेस्टेड इंटरेस्ट एंड contingent interest. Now what is vested interest? What do you mean by vested interest, right? So whenever I am transferring my property to someone, the interest gets vested in that person, है ना. सेक्शन 19 में आप देखोगे वेस्टेड इंटरेस्ट का डेफिनेशन है. सेक्शन 21 में हमारे पास कॉन्टिंजेंट इंटरेस्ट का डेफिनेशन है. तो व्हेन वी टॉक अबाउट वेस्टेड इंटरेस्ट, वी आर टॉकिंग अबाउट एनी ट्रांसफर जहां पे आप ट्रांसफरी को इमीडिएटली इंटरेस्ट पास ऑन कर देते हो. एनी ट्रांसफर जहां पे आप ट्रांसफरी को इमीडिएटली क्या कर रहे हो, इंटरेस्ट पास ऑन कर दे रहे हो, और इंटरेस्ट उसमें वेस्टेड हो गया. सो इफ आई एम मेकिंग अ गिफ्ट ऑफ हाउस टू यू, राइट, एंड सिंपली आई एम एग्जीक्यूटिंग द गिफ्ट डीड, द इंटरेस्ट इज वेस्टेड इंटरेस्ट, इट इज वेस्टिंग ऑन यू. ठीक है. और कंटिंजेंट इंटरेस्ट क्या होता है, यहाँ पर हम वेस्टेड नहीं करते इंटरेस्ट को, इट डिपेंड्स अपॉन सम अदर कंडीशंस आल्सो. सो कॉन्टिंजेंट मतलब ये होता है कि देर इज एन अनसर्टेन फ्यूचर इवेंट, and if it is depending on contingency, that means an interest which will only take effect when a specified uncertain future event is happening or does not happen. ठीक है. सेक्शन 20 अगर आप देखो, व्हेन अनबॉर्न पर्सन acquires vested interest on transfer for his benefit. सेक्शन 20 इज टॉकिंग अबाउट सेक्शन 13 एंड 14 से रिलेटेड है, जहां पे हमने डील करा विद ट्रांसफर फॉर बेनिफिट ऑफ अनबॉर्न पर्सन. तो यहाँ इस सेक्शन में दे आर स्टेटिंग 20 में दे आर स्टेटिंग दैट द इंटरेस्ट created in favor of an unborn person will become vested in him as soon as the person is born alive, है ना. So if the person is born alive, the interest will get vested in him. Even if the unborn person is not given position immediately, but the interest is vested. और contingent interest होता है कि contingency पे depend कर रहा है. It is depending upon a specified uncertain event which will happen or which will not happen. ठीक है. कम टू नाउ सेक्शन डिफरेंस आप देख लेना, वेस्टेड और कंटिंजेंट इंटरेस्ट का 19 और 21 का डिफरेंस देख लेना. ठीक है. 22 जो है दैट इज ट्रांसफर टू मेंबर ऑफ अ क्लास हु अटेन अ पर्टिकुलर एज, राइट. So 22, 23, 24 is, you know, is continuance of contingent interest ka, you know, sections. It is an extension of it. So read those rules. Come to 25. 25 talks about conditional transfer. अब कंडीशनल ट्रांसफर जो होता है, जब हम प्रॉपर्टी को ट्रांसफर कर रहे होते हैं तो हम प्रॉपर्टी को ट्रांसफर कर सकते हैं, एब्सोल्युटली ट्रांसफर कर सकते हैं या फिर पार्शियली ट्रांसफर कर सकते हैं. So if my transfer is absolute, it is unconditional transfer and the transferee will get the interest. There is no limitation, there is nothing. But if I'm transferring it conditionally, then there are certain conditions जिनको fulfill करना है और तभी वो transfer होगा. This is conditional transfer. Now that condition can be a precedent condition, that condition can be a condition subsequent. Condition precedent is the condition which is preceding the transfer. दैट मीन्स आपको पहले कंडीशन फुलफिल करनी है, उसके बाद ही हम ट्रांसफर करेंगे. सो पहले आप कंडीशन फुलफिल करो, देन वी आर गोइंग टू ट्रांसफर द प्रॉपर्टी, राइट. सो फॉर एग्जाम्पल, इफ आई वॉन्ट टू मेक अ गिफ्ट ऑफ माई हाउस टू यू, only if you marry X. So I will make a gift of house to you only if you marry X. This is a condition precedent, right? So only when you marry X, then only I will gift my house to you. So this is a condition precedent. आपको पहले condition fulfill करनी है, फिर transfer होगा. और condition subsequent होता है कि मैंने ट्रांसफर कर दिया आपको, बट आप कंडीशन बाद में भी फुलफिल कर सकते हो. एनीथिंग आप, मैंने आपको दे दिया है, ट्रांसफर कर दिया अपना फॉर्म, बट आप जो कंडीशन है बाद में फुलफिल करो, और अगर आप नहीं करते हो देन दैट ट्रांसफर विल बिकम वॉइड. ओके. कोलैटरल कंडीशन जो होती है, कंडीशन सब्सिक्वेंट, कंडीशन प्रेसिडेंट एंड कोलैटरल. कोलैटरल मींस जैसे ही मैंने आपको ट्रांसफर करा, आप भी कंडीशन फुलफिल करो. सो इट विल टेक प्लेस simultaneously. I will also fulfill my transfer and you will also have to fulfill your condition which I am making. ठीक है. And section 26 is talking about fulfillment of condition precedent, right. देखो उसी से रिलेटेड है 27 and 28 भी. And 29 talks about condition of fulfillment of condition subsequent, right. So these are related with the conditions only. All these are extensions of conditional transfer. Come to 35, election when necessary. So now 35 is again one important section. So after doing 25, 26 and 29, 25, 26 and 29, हम आ जाएंगे 35 पर. Section 35 which talks about election and when is election necessary, right. So section 35 talks about doctrine of election. Now doctrine of election means, you know, you have to elect here. It means choosing between two inconsistent or two alternative right. अगर आप section 35 देखो, डॉक्ट्रिन ऑफ इलेक्शन देखो, सो इट टॉक्स अबाउट चूजिंग. इलेक्शन मतलब ये होता है आपको चूज करना है. एंड व्हाट डू यू नीड टू चूज? यू नीड टू चूज बिटवीन टू इनकंसिस्टेंट और ऑल्टरनेटिव राइट्स. I'll just take a break of 10 seconds in between. Till that आप लोग please uh, just go on to read this doctrine of election from the Bear Act which is there. I'll take a 10 minutes break. 10 seconds break, sorry. 10 seconds break, ठीक है. We are back, students. Doctrine of election. अगर आप देखो doctrine of election. So as I told you, election means choosing between two inconsistent or two alternative rights. You are choosing between two inconsistent or two alternative rights. So अंडर एनी इंस्ट्रूमेंट, एक लीगल एक डॉक्यूमेंट के अंदर अगर आपको दो राइट्स मिल रहा है एंड it is said that you have to choose only one of them, then you are bound to elect or choose one of them only. So I cannot take, and I cannot, you know, take under and against the same instrument. So if I'm gifting you money, and in lieu of that money I'm telling you that you also have to transfer your house to someone else, right? So I'm gifting you money, and इस गिफ्ट के बदले में आप अपना हाउस ट्रांसफर कर दो टू सम थर्ड पर्सन, then you cannot be allowed to have both your house and the money. You have to choose between either taking the gift, or you can choose in retaining your house, right? If you don't want to take the gift, if you want to relinquish the gift and keep your house, then you can do that also. Then you will have to put it to election. So you cannot approbate and you cannot reprobate at the same time. You cannot approbate and you cannot reprobate at the same time. Matlab, you cannot take benefit and you cannot also keep the other thing. So आपको choose करना ही है. So if a person is professing to transfer a property not his own, तो पहले तो यहाँ पे एक person है जो एक property transfer करना चाहता है जो उसका नहीं है, and in lieu of this transfer, the transferor is conferring certain benefits upon the owner. So the transferring of property and the conferring of benefit is forming part of same instrument. Then owner of property is bound to choose or elect either to take up the benefit and transfer his property, or to retain his property and give up the benefit. तो ये दोनों चीजें आपको करनी है, या तो आप बेनिफिट रखो या तो आप प्रॉपर्टी रखो, राइट? आप मोड ऑफ इलेक्शन कैन बी इम्प्लाइड ऑल्सो. Implied कैसे होता है? अगर owner is enjoying the benefit for, you have started enjoying the benefit, और आपने रिफ्यूज भी नहीं किया, ना ही आपने ट्रांजैक्शन को डिनाई करा है, then it will be implied that you have elected for the benefit, right? So this is one thing. And there are rights of the transferee also. So if disappointed transferee के भी कुछ rights होते हैं, तो I wanted to transfer your house, and for that I have given you my gift of, I'm giving you a gift of some money. Now you are not accepting that gift. In that case, I will be a disappointed, the person to whom it was going to be transferred is a disappointed transferee. So if I told you that, okay, if I am telling to Ish that, Ish, will you take 10 lakh rupees, and he says, yes ma'am, I will take. And then I tell him that, okay, but you will have to transfer your house to X, and Ish says, no ma'am, I will not. So X is a disappointed transferee, because he was expecting, he was having hope of getting the property. Now this disappointed transferee also has some rights in case the transfer is gratuitous, right? And the transferor dies or becomes incapable of making the fresh transferor, and where the transferor is with consideration, if he is alive or dead at the time of election, the transferee is entitled to get a reasonable compensation from the transferor or his representative. Now reasonable compensation here means a compensation which is equal to the value of the property. So this he is not going to get from the owner, he is going to get from the transferor. So there are two people here, one is the owner, one is the transferor. Transferor is the person who is not the owner of the property, but he is professing to transfer it, right? So this is doctrine of election, very important, read it. Now you can skip many sections here, and you can directly come to section 41, which is ostensible owner. So after 35, skip the sections. Then see, you can read this section, but I'm coming to the important one, that is 41, which you cannot leave, which you cannot skip. Section 41 is important, transfer by ostensible owner. So section 41 talks about ostensible owner. Ostensible owner, what do you mean by ostensible? An ostensible owner is a person who is apparently the owner, है ना? Who is an ostensible owner? Student, anyone who knows what do you mean by the term ostensible? Tell me, what do you mean by the term ostensible? Yes. Ostensible का क्या मतलब होता है? Ostensible means apparent, right? An ostensible owner is a person who has all the indication that he is the owner, but actually he is not the owner. So ostensible owner has all the indications of ownership. He looks like the owner of the property, lekin actually mein he is not the real owner, right? Now if such kind of person transfers the property, है ना, then the transfer shall not be voidable on the ground that the transfer was not authorized to it. So previously we had बेनामी transactions, ठीक है, बेनामी transaction होता था, but that came but now after Benami Transaction Act of 1988, section 41 is subjected to the provisions of Benami transaction, right? And almost you will see that you have to follow the act of Benami transaction rather than going to section 41. But 41 says that it is not voidable. Any transfer by ostensible owner is not voidable. So there are two laws, one law which is prior to Benami transaction and one law which is after Benami transaction act, right? So this is again important. Ostensible owner is a person who is the apparent owner. Now come to section 43. Now 43 talks about feeding of grant by stopple. Okay? If you see 43, it is transferring by unauthorized person, it is feeding the grant by estoppel. Section 43 talks about feeding the grant by estoppel. Okay. So the transferor is an unauthorized person, right? So a person who has no title or no interest in an immovable property, he cannot transfer that property. क्योंकि हमने already competency में देख लिया that to be a competent transferor, you should be the one who is the authorized person to transfer also. So this section is providing that if a person has no authority, but अगर वो transfer करता है, then later he will be stopped from denying the transfer. अगर वो subsequently he is acquiring that authority, then he cannot deny that transfer. ठीक है? So this is a common law doctrine of estoppel by deed. If you see section 43, it's a common law doctrine of estoppel by deed, right? आपको स्टॉपल जो है वो मिल जाएगा इन एविडेंस एक्ट ऑल्सो, वेयर इन विच सेक्शन ऑफ एविडेंस एक्ट डू यू गेट स्टॉपल 115. ठीक है? एंड स्टॉपल के जो काइंड्स हैं वो है स्टॉपल बाय पेस, स्टॉपल बाय डीड, राइट? So so this is one thing which you have to see, right? So when you see the estoppel that is in section 115, and here also we are talking about estoppel. Now this section 43 talks about estoppel by deed. Okay, so if you are making a promise, you cannot deny it later after after acquiring that property. This is what section 43 says. तो 43 के बाद हम आ जाएंगे सीधा इन विच इज इम्पोर्टेंट राइट नाउ. 43 के बाद आप पढ़ सकते हो डायरेक्टली 48 which talks about priority of rights. ठीक है? 48 priority of rights. Who should be the one who will have a prior right? So there is a maxim Q prior est tempore posture est jure जो आता है. Yes, Ish, 115, right? Now there is one maxim. I'm writing it. Q prior est tempore posterior est jure. Okay, related with section 48. See, I have written in the chat box. The maxim I have written in the chat box. It means first in time and better in law. First in time is better in law. Right? So this section talks about priority of rights, and it is dealing with cases if if you are purporting to create by transfer at different times, आपने different rights create किया है, ठीक है? Then all such rights cannot exist or be exercised to their full extent together. Each later created right shall, in absence of a special contract or reservation binding the earlier transferees, be subject to the right previously created. तो अगर हम डिफरेंट राइट्स में डिफरेंट केसेस डिफरेंट राइट्स क्रिएट कर रहे हैं, सो द वन हु इज कमिंग फर्स्ट, राइट? फर्स्ट जो है फर्स्ट कम फर्स्ट सर्व वाला जो चीज है, फर्स्ट जो आपने प्रीवियस ट्रांसफर करा है, ऑल द सब्सिक्वेंट ट्रांसफर्स विल बी बाउंड बाय द प्रीवियस ट्रांसफर्स. ठीक है? कम टू 52 नाउ. 48 के बाद हम आ जाएंगे 52 पर. नाउ this 52 is relating to my lis pendens. Section 52 talks about lis pendens. Lis pendens का क्या मतलब होता है? If I say section 52, we talk here about lis pendens. Now this is based on the doctrine that pending litigation, if there is a doctrine here in section 52, I'm writing that doctrine in the chat box. अगर आप देखो, it's pendente light. If you have heard of it, anyone who knows pendente light nihil innovator, ये जो डॉक्ट्रिन है, ठीक है, ये जो मैक्सिम है पेंडेंटे लाइट निहिल इनोवेटर, इसका मतलब क्या है? ड्यूरिंग पेंडेंसी ऑफ लिटिगेशन Nothing new should be introduced. So during pendency of litigation, you cannot introduce anything new. So under this doctrine, the principle is that during the pendency of any suit regarding title of the property, you cannot create a new interest in respect of the property. ठीक है? तो आप लिस्ट पेंडेंस अगर है मतलब if there is any pending litigation, you cannot introduce anything new. So if there is a pending suit or proceeding in a court of competent jurisdiction, right, and एक immovable property से related कोई right है जो वहां पर involved है, right, then in that case you cannot transfer that. And if you are transferring, then the transferee is bound by the decision of the court. अगर आपने ट्रांसफर कर भी दिया तो जो भी कोर्ट का डिसीजन होगा, the transferee will be bound by that decision of that court. ठीक है? Then come to 53. 53 is again an important section. It talks about fraudulent transfer. ठीक है, fraudulent transfer के बारे में यहाँ बात हुई है. 53 is again important. So when I talk about fraudulent transfer, it means there are two things here. ठीक है, पहला तो there is a transfer of immovable property and this transfer is fraudulent. That means it is made with the intent to defeat or delay the creditors or the transferor. And अगर आप fraudulent transfer करते हो, it is voidable at the option of creditor. If you are transferring fraudulently, it is voidable at the option of creditor, whoever is defeated or delayed. So this kind of transfers are voidable. So if you are making any transfer which is made with the intent to defeat or delay the creditor of the transferor, in that case it will be voidable at the option of creditor, right? And you know about sham transfers. Sham transfers bhi yahan pe included hai. That means fictitious transfer. Sham transfer, that is fictitious transfer, right? Now come to 53A. 53A talks about part performance. 53A part performance, again a very important doctrine. Again, this is an equitable doctrine, and it means that if a person has taken possession of a property, okay, and he is willing to perform his part in the contract, then you cannot eject him from the property on the ground that the sale is unregistered and title is not passed to him. So ये है part performance. So if anyone, any transferee is wishing or is ready to perform his things, is to perform the things which is mentioned in the contract, either he has performed his part or he is willing to perform his contract, then you cannot eject him on the ground that the deed is not registered or something, right? So this is to protect the transferee. But there is a proviso also which says that it is not going to affect the right of transferee for consideration. Okay? There is a proviso also attached with section 53A. तो ये हमने फिनिश करा चैप्टर 2. नाउ कम टू सेल. नाउ सेल इज अ वेरी इजी चैप्टर. ठीक है, 54 से हमने बात करी कि 54 से 57 तक यू हैव सेल का प्रोविजन. You know what is sale? Sale ka definition is given under section 54 only. It's transfer of ownership, है ना? It's transfer of ownership, and it is for a price paid. So whenever, so यहाँ पर एक money consideration है, और money consideration है जो इसको काफी सारी चीजों से अलग भी करती है. अगर हम बोले that सेल और एक्सचेंज में क्या डिफरेंस है, तो सेल में मेरा मनी इज इन्वॉल्व, है ना? मनी इज इन्वॉल्व. एक्सचेंज में हमारा मनी इन्वॉल्व नहीं होता. एक्सचेंज में आप एक ओनरशिप की जगह दूसरे ओनरशिप को लेते हो, बट सेल में यू हैव अ पर्सन, the parties who are seller and purchaser who are competent. There is a property, there is a money consideration, and there is a transfer of this property, right? And how will the sale made? See, the how is the sale made? um, In case of tangible immovable property, if it is above 100 rupees and upward, or in case of reversion or other intangible thing, it can only be made by a registered document. तो यहाँ पे हमने हमने मोड देख लिया, how it is affected sale, how it is made or how it is affected. If your property is above 100 rupees, or in case of reversion or other intangible thing, it is only by registered instrument. In case of tangible movable property which is less than 100 rupees, it can be made either by registered instrument or by delivery of property. Or tangible immovable property takes place when the seller places the buyer or such person as the direct in possession of the property. Now there is a definition for contract for sale also, which is a contract that the sale of such property shall take place on the terms and conditions between the parties. Okay, so contract for sale is also defined here. Then you will just read about the distinction between sale and contract of sale. Sale and gift का क्या क्या डिफरेंस है, सेल एंड एक्सचेंज में क्या डिफरेंस है ना. गिफ्ट में तो हम पैसे नहीं लेते, लेकिन सेल में हम पैसे लेते हैं, है ना, मनी इज इन्वॉल्व. नाउ कम टू 55 विच इज इम्पोर्टेंट. तो इस चैप्टर में सारे ही सेक्शंस इम्पोर्टेंट है. 55 इज अगेन इम्पोर्टेंट विच टॉक्स अबाउट राइट्स एंड लायबिलिटीज ऑफ बायर एंड सेलर. ठीक है ना. अभी यहाँ पे अगर आप देखो तो आपको एक चार्ट बनाना होगा. What is the right of seller before sale? What is the right of seller after sale? What is the duty of seller before sale? What is the duty of seller after sale? What is the right of the buyer before sale? What is the right of buyer after sale? What is the duty of buyer before sale? What is the duty of buyer after sale? तो ये चारों चीजों को आपको यहीं पे सेक्शन 55 में बाइफर्केशन करनी है. That there is before sale rights and duties and there is after sale rights and duties, and rights and duties are for both seller and for buyer both, right? So in the absence of contract to contrary, मतलब this is subject to contract. अगर आप कोई contract बनाते हो तो वो contract के according it will be um, it will be going. बट अगर कॉन्ट्रैक्ट नहीं है देन जनरल राइट्स एंड ड्यूटीज क्या है हमारे सेलर के और बायर के. तो बिफोर सेल इफ यू सी द सेलर हैज सर्टेन ड्यूटीज. एक सेलर का ड्यूटी क्या होता है बिफोर सेल. 55 में सब कुछ है. फर्स्ट इज डिस्क्लोजिंग मटेरियल फैक्ट्स इन द प्रॉपर्टी और टाइटल. If any material defect is there in the property, you have to disclose. The seller has the duty to disclose it before selling the property. He has to disclose it to the buyer if there is any material defect. To produce title deeds for inspection is also the duty of the seller before sale. He has to produce all the title deeds for inspection. He has to answer all relevant questions also as to title. To execute conveyance also. To take care of the property and title deed. So before sale ऐसा नहीं कि हम सेल करने वाले हैं तो हम प्रॉपर्टी का ध्यान नहीं रखेंगे. हमें प्रॉपर्टी का प्रॉपर टेक केयर करना है. एंड टू पे ऑल द आउट गोइंग्स ऑल्सो इज द ड्यूटी ऑफ द सेलर. ऑल दिस इज द ड्यूटी ऑफ द सेलर बिफोर सेल. आफ्टर सेल उसकी क्या ड्यूटी है. आफ्टर सेल उसकी ड्यूटी ये है कि वो अपना पोजीशन बायर को दे दे. टू गिव पोजीशन टू द बायर. टू कवेनेंट फॉर टाइटल एंड टू डिलीवर टाइटल डीड्स ऑन रिसीट ऑफ द प्राइस. ठीक है, ये उसका आफ्टर सेल ड्यूटी है. Now after sale he also have a charge or a lion which आप देख पाओगे section 55 clause 4 clause B में. Seller's right after sale. Okay, so there is a right before sale and after sale. So before sale he has certain rights, right, like he has a right to realize the interest on unpaid purchase of money, or he is also entitled to all rent, profit and other beneficial interest. Okay, before sale he has all these rights. But after sale he has a right of lion. That means if there is any unpaid amount, then the seller will have a charge or a lion on the property. Okay, so he will have a, and that unpaid price is like a debt, so he can also claim interest on it. ठीक है. बायर की ड्यूटी क्या है एंड बायर के राइट्स क्या है. बायर्स ड्यूटी बिफोर सेल इज टू डिस्क्लोज facts which is materially increasing the value of the property. Any fact which is materially increasing the value of the property, he has to disclose that fact, or he has to pay and second is to pay the price. This is also his duty. After sale his duty is to bear the loss to the property and to pay the outgoings. All the other outgoings after sale is his duty. And what are his rights, right? So before sale if he has paid any amount, he has a charge on the property if he has paid any amount. And after sale you will see that he will become the owner of the property, so he will be entitled to all the benefits and everything which the seller has, right? So he will be one. Now come to 56. 56 is again an important section which talks about marshalling. मार्शलिंग बाय सब्सिक्वेंट परचेजर. नाउ मार्शलिंग मीन्स अरेंजिंग थिंग्स. ठीक है, मार्शलिंग मतलब होता है अरेंजिंग थिंग्स. अगर आप इसका इलस्ट्रेशन देखो और प्रॉपर्ली इसको देखो तो आपको समझ में आ जाएगा. मार्शलिंग इज ऑल्सो देयर इन मॉर्गेज, मार्शलिंग इज ऑल्सो हियर इन section 56. So there are two marshalling, one for sale and one for mortgage. So marshalling means arranging something. So the purchaser has a right to make arrangements with regard to sale of the property if it is mortgage, and he will make it in a manner that the mortgage debt has to be satisfied out of the property not sold to him. So if you are buying a mortgage property, you have a right, and you have bought it, you have a right to arrange things in a way कि आप बोल पाओ मॉर्गेजर को कि पहले वो अपना मॉर्गेजी को कि पहले वो अपना सारा पैसा दूसरे प्रॉपर्टी से सेटिस्फाई करे. अगर नहीं होता है देन ही शुड कम एंड claim, have a claim on his property. So this right of marshalling is available to a purchaser, whether he has a notice of mortgage or not, but he gets this right. And then 57 is discharge of encumbrances on sale, which is provisioned by court for encumbrances and sale fees therefrom. ये उतना important नहीं, आप इसको बस read कर लेना. But 54, 55 and 56 is really important. Come to chapter 4. Chapter 4, which is mortgage and charge. It is dealing with mortgage and charge both. 58 तो इतना important है that you will have to read it. So if you see section 58, very important section, यहाँ पर mortgage का definition है. You know what is a mortgage? It is a interest in a specific immovable property for the purpose of securing payment of money. तो अगर मुझे payment of money secure करनी है, and for that purpose if I am mortgaging, अगर मैं गिरवी रख रही हूँ कोई property को, right, to just to secure the debt or to secure a loan, it's a mortgage. The transferor here is called the mortgager. The transferor here is the mortgagee, and the principal money and interest जो secure होता है वो mortgage money है. And how many types of mortgage are there? आप देखो, simple mortgage, okay, simple mortgage, mortgage by conditional sale, usufructory mortgage, English mortgage, mortgage by deposit of title deeds, and anomalous mortgage. There are 6 kinds of mortgages as defined under section 58. With each mortgage you also have to study the remedy. So whenever you are reading mortgage you have to study the remedy also. ठीक है, सिंपल मॉर्गेज में पोजीशन डिलीवर नहीं होता है. मॉर्गेज बाय कंडीशनल सेल में इट्स ऑन अ कंडीशन दैट if the payment is not made then it will by default it will become a sale will become absolute. usufructory mortgage में जहां में mortgage deliver करता है अपना पोजीशन and he like allows कि चलो आप अपना benefit and ले सकते हो. English mortgage is you're binding yourself to repay the mortgage money, and and you transferring the mortgage property absolutely to the mortgagee, but subject to the proviso that the mortgagee will retransfer the property if the mortgager pays the amount. Mortgage by deposit of title deeds अगर आप देखो जहाँ this was only in the town of Calcutta, Madras and Bombay जहाँ पे UK, or if the state government is notifying for any state where you deposit your title deeds. And anomalous mortgage is any other kind of mortgage which is not coming within this before prior which is not simple or by conditional sale or usufructory or English or by deposit of title deed is a anomalous mortgage. ठीक है, तो ये पढ़ लेना. 58 बहुत इंपॉर्टेंट है. इसके साथ अब सारे रेमेडीज पढ़ना, इसेंशियल्स भी पढ़ना और सारे रेमेडीज भी पढ़ना इन मॉर्गेज. सो दिस इज इम्पोर्टेंट, right? Now rights and liabilities of mortgager is again very important. What are the rights of mortgager and mortgagee? ये again बहुत important part है, right? पहले तो आप ये भी पढ़ना right of redemption. Right of redemption is again one of the rights of uh, you know मॉर्गेजर. और जैसे मॉर्गेजर के पास राइट ऑफ रिडेम्पशन है वैसे ही मॉर्गेजी के पास राइट टू फोरक्लोजर और सेल है. तो रेमेडी आप जरूर पढ़ना, हर मॉर्गेज से रिलेटेड एक रेमेडी है. सो राइट ऑफ रिडेम्पशन एंड राइट ऑफ foreclosure is very important. There is one thing which is called redeem up and foreclose down, ठीक है, वो भी आपको देखना है. And once a mortgage always a mortgage, this is one thing again which you have to see along with clog on redemption, right? Along with clog on redemption, this all you have to study. Now, what are the rights and liabilities of mortgager and what are the rights and liabilities of mortgagee? This is again very important, okay? So right of redemption is one of the rights of mortgager. ये एक right है. उसी तरह mortgagee के भी कुछ rights and duties है that you have to go through. Rights of mortgager and mortgagee, please go through those rights. And section 60 जो है that is talking about my right of redemption, ठीक है. Section 60 talks about rights of mortgager to redeem. So this is the right. And अगर आप second portion देखो तो it is prohibiting partial redemption also. So इसके साथ आप पढ़ना once a mortgage always a mortgage, clog on redemption, and also um, go through this redeem up and foreclose down part, ठीक है. So redemption is a very important topic. And along with it you have 60A, 60B, 61. So we have rights of mortgager. We have rights of mortgager which is starting from, if I show you, rights and liabilities of mortgages starts from section 60 and ends at section 66. All this deals with rights and liabilities of mortgager, ठीक है. यहाँ राइट्स एंड लाइबिलिटीज ऑफ मॉर्गेजर प्रॉपरली दिया है फ्रॉम सेक्शन 60 till section 66. And rights and liabilities of mortgagee is given from section 67 till section 77. 10 rights and liabilities given, जिसमें 74, 75 and is repealed only, ठीक है. Right to foreclosure or sale is one of the most important rights of mortgagee. So please go through it. So if I tell you in short what are the rights and liabilities of mortgager, right, that is from section 60 till section 66. आप देखना, right to redeem the mortgage, right of inspection and production of documents, right to redeem the mortgage separately and simultaneously, right to appropriate accession, right to appropriate improvement, right to renewal of lease if the mortgage is a leasehold property, right to effect lease of mortgage property. And if you see duties of mortgager, again it is incorporated in section 65 and 66 में हमें मिल जाएंगे duties of mortgager. That is the liability to guarantee his title in the mortgage property, to defend his title in the mortgage property, to make payments and public charges, to pay rents of the mortgage property if it's a leasehold property, liability to discharge prior encumbrances of mortgage property, liability not to commit waste on the mortgage property, ठीक है. Then you come to mortgagee ka rights you will see from 67 to 73. And it is right to foreclosure or sale in case of default of payment. Then the second right is to sue the mortgager for recovery of mortgage money, right to exercise power of sale if given under the mortgage deed. He also has a right to get a receiver appointed. He also has right to accession to mortgage property, right to have the benefit of renewed lease if mortgage property is a leasehold, right to spend money in preserving the property, defending the title or in renewal of lease, and right to receive proceeds of revenue sale. Liability आपको मिल जाएगा 76 में, ठीक है. And the liability is to manage the property with ordinary prudence, to collect rent and profit with due diligence, to pay the government dues in case there is a contract to the contrary, if to spend money for necessary repairs, not to commit waste on the property, to apply for insurance money, है ना. ये सारी चीजें उसकी liability है. Then come to 78. Now 78 talks about priority, ठीक है. If I come to 78, it talks about priority. After coming from rights and liability, this postponement of prior mortgagee. So this is the doctrine of priority. Now section 78 is not dealing with the rule of priority. It is an exception to the doctrine of priority. What is the doctrine of priority? The doctrine of priority is given in that only that prior in time is prior in right, जो मैंने आपको पहले भी बताया था. Q prior जो section 48 में था. Q prior est tempore posterior est jure. But section 78 is not dealing with the rule of priority. It is an exception to the doctrine of priority. Right. Come to 81. 81 जो हमने पढ़ा marshalling अभी in sale, there is a marshalling again here also in mortgage also in section 81. Again it means arranging things. So यहाँ पे भी जो you know subsequent mortgagee है, he has a right, the subsequent mortgagee has a right that he can tell the the previous mortgagees to settle their debt amount from the property not mortgaged to him first, and then come to his property if they don't get the amount satisfied. 82 talks about contribution to mortgage debt. ठीक है, contribution मतलब सारे लोग money provide करते हैं for a common fund towards the mortgage debt. So 81 and 82 you will read about marshalling and contribution. ठीक है. Then come to 92, which talks about subrogation. Subrogation means when you step into the shoes of someone else, है ना. तो अगर कोई mortgager या co-mortgager है ना who has interest in the property and he wants to redeem the mortgage, he will be entitled to be substituted in place of mortgagee after fulfilling the debt. So the moment he fulfills the debt, he steps into the shoes of mortgagee. Now subrogation is of two types: legal subrogation and conventional subrogation. Then we have 93, which is prohibition of tacking. Now tacking अगर आप देखो, it means uniting one thing with the other. तो tacking means you are annexing a security with another security. ठीक है, तो यहाँ पे वो prohibit हो रहा है. Then we have other sections also which you just read. Then come to charge in section 100 to 104 deals with charge. Now charge means, अच्छा वन थिंग, रिडीम अप फोरक्लोज डाउन आपको मिल जाएगा सेक्शन 94 में. ओके, दिस इज रिडीम अप एंड फोरक्लोज डाउन का कॉन्सेप्ट इसी सेक्शन में दिया है, तो ये भी आप पढ़ लेना. Charges, if you see, you know what is a charge. A charge is something which is not mortgage and it has very thin difference. So in every mortgage there is a charge, but charge is not mortgage. ये आप याद रखो. तो charge and mortgage का difference पढ़ना जरूरी है. And charges are of two kind. It is created either by act of parties. If you see charge, so charge is of two kind. It is either created by act of parties or it is by operation of law, right? And 102 talks about the service or tender on this. Then come to lease, the chapter which is chapter 5 of lease of immovable property. तो यहाँ पे हमारा लीज का डेफिनेशन है, लेसर, लेसी, प्रीमियम, रेंट, सारी चीजें डिफाइंड है. नाउ लीज क्या होता है? देयर शुड बी वन ट्रांसफर एंड ट्रांसफरी, and you are getting the right to enjoy immovable property, and there is a duration period, and there is a consideration which is the premium or rent, right? Which is the premium or rent. So it's a transfer of the right of enjoyment of an immovable property only for a certain period. यहाँ पर हम सेल नहीं कर रहे हैं, यहाँ पे हम सिर्फ एक टाइम पीरियड के लिए आपको एंजॉय करने को दे रहे हैं, और इसके बदले हमें क्या चाहिए? हमें चाहिए कॉन्सिडरेशन में लीज, द प्रीमियम और द रेंट, राइट? सो लीज आप जब पढ़ रहे हो तो यहाँ पे लीज इज हाउ मेड 107 में, द मोड इज गिवन हाउ टू मेक अ लीज, राइट? एंड राइट्स एंड लायबिलिटीज ऑफ लेसर एंड लेसी पढ़ना है. सो राइट एंड लायबिलिटीज ऑफ लेसर एंड लेसी इज गिवन अंडर सेक्शन 108, राइट? सेक्शन 108 में सारे राइट्स एंड लायबिलिटीज दिए हैं ऑफ लेसर एंड लेसी. सो गो थ्रू दिस and I'll directly go to the chapter of exchange now, which is under 118. Exchange is a very easy chapter. If it is just it is a transfer of ownership for consideration of ownership of another property. तो एक्सचेंज में आप पैसे नहीं पे कर रहे होते, आप एक प्रॉपर्टी ले रहे होते हो और दूसरे प्रॉपर्टी को दे रहे होते हो. सो इट इज जस्ट फॉर कंसिडरेशन ऑफ अनदर प्रॉपर्टी का ओनरशिप. इट इज नॉट फॉर मनी और प्राइस ऑफ सेल. ठीक है, सो इट इज एक्सचेंज. सो यू आर ट्रांसफरिंग द ओनरशिप. द प्रॉपर्टी हियर नीड नॉट बी immovable. Okay, so the subject matter of exchange need not be immovable, it can be movable also. Now exchange is including something which is like barter system. आपने ये दिया, मैंने ये दिया, and the mode of transfer is given in 118 का second paragraph, that it can be made in any manner in which the sale is effected. ठीक है, तो जैसे सेक्शन 54 में सेल हाउ इफेक्टेड था, सेम चीज एक्सचेंज भी आप कर सकते हो, मतलब 100 रुपीज से ऊपर के लिए रजिस्ट्रेशन इज कंपलसरी, 100 रुपीज से नीचे के लिए रजिस्ट्रेशन इज ऑप्शनल, लाइक दैट, राइट. I'm just read about the right and liabilities given under section 120, which is same as that of seller and buyer ka rights and liabilities, which we did in section 55. Okay. Come to gift. Gift is chapter 7. Gift is what? Gift is a transfer of property without any consideration. So the first thing you have to understand is this gift is transfer of ownership only, but no consideration is taken here. Enough? No consideration is taken here. And how is this affected? Very important. ये फिर से important है. If you are transferring a gift of immovable property, it should be effected by registered instrument only, which has to be signed by or on behalf of the donor, and it has to be attested by two witnesses. And if you are making a gift of movable property, it should be either by registered instrument or by delivery. So registration here is optional in case of movable. The transfer can be effected, either by registered instrument or by delivery. So it's optional here in that case. And if you are gifting to several persons of whom one does not accept, then a gift of a thing to two or more donee of whom one does not accept is void as to the interest which he would have taken had he accepted. And gift of existing and both existing and future property is void. ठीक है, तो आप any gift which is, so this section is making very clear that gift of future property is void. So अगर हम दो प्रॉपर्टी देते हैं एक साथ जिसमें one is existing and the other is not, then the whole gifts get void. Similarly, if you are making gift to two or more persons jointly and severally, and one of them does not accept, right? So acceptance by all donees is necessary. And if I'm giving it jointly, then सबका acceptance जरूरी है. ठीक है. 126 is important. Suspension and revocation of gift. 126, when can you suspend or when can you revoke a gift, right? Now revocation can be by mutual agreement, and revocation can be by rescission of contract also. Okay. 127 talks about onerous gift. Onerous gift is a gift which is burdensome gift. Okay. Onerous gift is burden gift. So it's a gift of property which is already burdened with liabilities, and it is a non-beneficial property. So what will you do with a property jo already it's coming with so much liability? So there is a maxim: quis ensit commodum debit et sentior onus. That means one who accepts the benefit of transaction has to also accept the burden. You cannot accept the gift and leave the burden. You are accepting the gift with a burdened thing. And onerous gifts to disqualified person: if you are giving onerous gift to a disqualified person, like to a minor, and such donee is accepting the gift, but later if he finds that no, after attaining majority he sees that this gift is not beneficial to me, he can repudiate it. Okay. 128 is universal donee. Universal donee means one who gets all the property, movable, immovable, everything. So universal donee is one donee who is getting everything. Okay, he gets all the property. And 129 is the saving of donations, mortis causa, and Mohammedan law. Now, this section is exempting two gifts from operation of this chapter, and these two gifts are Muslim gifts, that is hiba, if the donor is a Muslim, and gift of movable properties made in contemplation of death. Okay, that is also uh, exempted from here. Come to actionable claim, which is the last chapter 8, 130 से 137. ये है actionable claim. As I told you, actionable claim, as I have told you all, is or incorporeal movable properties. So they are the beneficial interest in the movables. If you see section 3, हमने section 3 में already actionable claim के बारे में definition पढ़ा था, जिसमें unsecured money debt है and beneficial interest in movables not in possession of claimant है, right? Now movables is a choices in possession are tangible movable property. Movables which are choices in action are intangible movable properties. ठीक है, तो यहाँ पर आपको ट्रांसफर ऑफ एक्शनेबल क्लेम मिलता है with exception it does not apply to the transfer of marine or fire policy or insurance, or it does not affect the provisions of section 38 of insurance act. Okay, so 130 is this. 131 is says that the notice has to be in writing and signed by the transferor or his agent. 132 is the liability of transferee of actionable claim. So this is the liabilities. Okay, it says the transferee of actionable claim shall take it subject to the liabilities and equities to which the transfer was subject in respect thereof at the date of transfer. 133 talks about the warranty. 134 talks about mortgage debt. Now this is important. See, actionable claim is property and transfer of this property by way of mortgage is possible because actionable claim is by unsecured money debt. So it can be secured by another debt, that is by another actionable claim. So if a debt is transferred for security, for securing another, say for example, existing or future debt, it is nothing but transfer of actionable claim by way of mortgage. So this is being said in 134. 135 talks about the assignments of right under policy of insurance against fire. And 136 you can see incapacity. So some people are there who cannot be assignees of actionable claim. There are some people who cannot be there are some people who cannot be assignees of actionable claim. That is, there are incapacity, they are incapable to become assignees of actionable claim, legally disqualified person. And who are they? Judge, legal practitioner, or officer connected with any court of justice, right? So judge, legal practitioner, and officers who are connected with court of justice, if they are buying or they are in agreeing to receive any share or interest in any actionable claim, they cannot do so, right? Then what 37 is the saving of NI, negotiable instrument. So it talks about the mercantile goods, document of title and all. So under 137, you will see that documents which are in the nature of negotiable instrument are also exempted from the operation of the provision of this chapter, right? Mercantile document of title to goods is already enumerated in the explanation. That transfer is governed by law or custom of the merchant. है ना? So this is it from section 1 till section 137. And then we have the schedule. And then we have the schedule, which is here, not important. I have already I have already given you the important sections which you have to go through from chapter 2 and when I was doing that. So hope that you all enjoyed the session and understood in brief whatever I could tell you in this 2 hours. Okay. So as I already told you, section 1 is important. I'm again repeating the important section 1, section 3, section 1 and section 3. Now here in this chapter 2, 5 and 6 is important. 7 and 8 you can read, all these other thing you can read. So 5 and 6 is important things which you have to read in depth. Section 10 you have to read in depth. 13 and 14 you have to read in depth. 19 you have to read in depth. 21 you have to read in depth. Okay. Then 25, 26, 29, 25, 26, 29. Then you can skip to 35. See, read all the other sections, but this section which I'm telling you, you have to read properly. Then come to 35. After 35 you can directly move to 41, 41 and 43, 41 and 43. Then you can come to 48, priority of rights, right? 51, 52, sorry, 52 and 53 and 53A. These last three sections are very important. From sale, please go through 54, 55, 56. 54, 55, 56, very important. Mortgage 58, very, very, very important. 58 is very, very, very important. Then 60 is very important. From 60 to 66, just read. But 60 is very important, but you have to study also from 60 to 66. 67 is again very important, but please go through 67 to 77. Priority is also important. 78, 81, 82 is also important. Okay, 81, 82 is important. Many sections are repealed. 92 is important, 93 is important, 94 is important, 92, 93, 94. 100 is important. 100 से 104 तो आप पढ़ ही लो एक बार, बट 100 एंड 101 पढ़ना है. 100 एंड 101 यू हैव टू स्टडी प्रॉपरली. लीज में तो आप वही पढ़ो, डेफिनेशन यू हैव टू रीड अबाउट द ड्यूरेशन, राइट्स एंड लाइबिलिटीज ऑफ लेसर एंड लेसी, जहां पर टेनेंसी की बात है वो भी आपको पढ़ना है. इफेक्ट ऑफ होल्डिंग ओवर भी आपको पढ़ना है. एक्सचेंज इज अ वेरी इजी चैप्टर. इफ यू जस्ट गिव वन रीडिंग यू विल अंडरस्टैंड इट. गिफ्ट में आपको 122 पढ़ना ही है, 123 पढ़ना ही है. ये सारा गिफ्ट इज ऑल्सो इम्पोर्टेंट. गिफ्ट के सारे सेक्शंस आर इम्पोर्टेंट. आई विल नॉट मार्क एनीथिंग इन गिफ्ट, इट इज इम्पोर्टेंट. एक्शनेबल क्लेम भी आप एक बार रीड कर लो, बट 130 एक बार अच्छे से पढ़ना. 130, 131, 134, 136, ऑल दीज आर इम्पोर्टेंट. अदरवाइज बाकी सब तो पढ़ना ही है. Right, so I hope you all enjoyed the session. Thank you so much for your patience, students. So we can end the session now.